wheel right around and talk to our friend Marshall Chriswell. And it's Martial Law. This radio program intended to be for informational purposes only. The information does not constitute legal advice. The law is constantly changing. The information may not be complete or correct depending on the date and your particular legal problem. Each legal problem depends on its individual facts, and different jurisdictions have different laws and regulations. Because of that, you should not act or rely on any information in this segment without seeking the advice of a competent attorney licensed to practice law in your jurisdiction for your particular problem. There's one of those on the other end of the line with me this morning. He's Marshall Chriswell. Good morning.
Good morning.
It's good to have you with us here today. We've been talking recently about a number of different topics, but last week we were talking about estate law in a different way, and I want to talk today about a complicated scenario. And I know that in today's day and age, it's easy to come into complicated scenarios, but estate planning for people in second marriages and even third marriages, when you have multiple marriages and all the different issues that come with that, sometimes there can be entanglements to work your way out of. Is that true?
That is absolutely true. Some of the more the more interesting and difficult situations we deal with in estate planning are blended family situations. Folks that have moved on either from a first marriage that was terminated either by the death of one spouse or divorce, and moving on to another relationship and eventually a second marriage, and now you have a blended family with each side maybe having children, often adult children, and those children, don't necessarily have a relationship with each other. So it makes for a kind of some naughty problems whenever you're planning, doing estate planning.
I'm guessing that a lot of those problems have to do with the children and the fact that there could be inheritance difficulties from one family to another, especially when the children from, say, the second marriage really don't have any connection to the property from the first marriage. Let's put it that way, but frame that out for me a little bit.
Sure. When spouses come into a marriage later in life, they're bringing with them all of their assets, and usually nobody's on equal footing down to the dollar when it comes to your financial worth, and so there's usually some level of inequity there, and so figuring out, all right, what's going to happen whenever one of us passes away. What's the goal? And most of the time, the spouses will say, well, whenever one of us passes, we want our surviving spouse to have most or all of the assets. But when that surviving spouse passes away, there's a certain percentage of assets we want to go back to our children from our respective marriages, and so that creates an issue, right? Because what happens if my spouse and I are agreeing on this right now, and then down the line one of us passes away, and the other spouse decides, well, I'm going to change the plan. Right. I know that I was supposed to give these assets or this percentage of assets back to, my stepkids, but that doesn't seem right now, so I'm going to change it. And how do we avoid that situation?
Mm-hmm. Yeah, and I would guess that it's not just a tiny little problem for that person who wants to make that change, that the wishes of the spouse who is no longer a part of the picture must be respected in some way.
That's right, and there are several methods that we use to create a binding agreement. So you can use if folks have wills. If you create a will for each spouse setting forth the terms of distribution, you can use what's called a contract for a will. And both spouses sign a separate contract which says, hey, I agree that I am never going to change my will. After my spouse passes away, it's going to stay as it is until I die. So that's one kind of simple way to do it, but simple solutions often aren't the best solutions because there may be circumstances where the spouse does need to change the will for legitimate purposes. So that's one way to do it. Another way is to create a post-nuptial agreement where you lay out what part of the assets are to be considered marital property, what part of the spouse's assets are to be considered separate property, and create an agreement that way, and that can be much more detailed, and that can work. Probably the most popular way to resolve this, probably the best way to resolve it, is to use a trust, a trust which specifically spells out what rights your surviving spouse has to your assets when you're gone, so let's say I pass, we have a home. Let's say I have a home that I brought into the marriage, and that's where we live. Is my premarital home. Whenever I pass, I can have a trust that says my spouse can live there for the rest of her life, and she could even rent if she needed to downsize and move out, and she wanted to rent out that property and have some income. She can do that. She can have full use of the property for the rest of her life. But when she's no longer here, the property it has been held in trust, and now it's to be distributed back to my children. And we can do that with all sorts of assets. And the thing about the trust is that it's what we call an irrevocable trust. So it's not something that can be fooled with once I'm gone. So there are lots of ways lots of options for spouses in second marriages to plan for the ultimate disposition of their assets. But the important thing is that you do something, because I've seen too many situations where, and people don't realize this. Mm-hmm. If you don't have a will at all, and you pass away, and you have a surviving spouse and you have children from a prior marriage, your surviving spouse is only going to get 50% of your assets. One half to the surviving spouse and one half to the children. So, most people think, well, when I die, my spouse is going to get whatever I have. That's not what Pennsylvania law says.
Yeah. Yeah, and that's something that we've talked about before, and that might surprise a whole bunch of people. I would guess, and again, I'm just throwing out postulations at you, but I would guess that the amount of preliminary work that you put into this is really going to determine what the payoff is in the end. That once you have the assurance that you've done the work ahead of time, then when that time comes, that the issue comes to the front, you already have everything done, and so it makes it really, really incumbent upon you to think of these things now when you're in the full of your health, as opposed to later on.
Yeah, absolutely. And as we've discussed before, you never want to wait until it's almost too late to create an estate plan, or it is too late. As far as someone being able to understand and be competent to participate in the necessary decisions to create an estate plan. Absolutely. The work on the front end, what we're doing is creating clarity. Yeah, we're putting a trust in place. We're doing legal strategies to achieve a goal, but also we're creating clarity for the family moving forward. And as I always say, I think transparency in these matters is really important between the spouses, obviously, but between the spouses and their children is extremely important. I see too many situations where you have second marriages, third marriages, and when the time comes, the children didn't know that. The children from mom's previous marriage and dad's previous marriage, we're all inheriting real estate together. we don't even know each other. That's a lot of times you don't have really any relationship, and the parents have formed relationships, right, with their stepchildren. But if you're adults, you probably don't get together with your new adult stepchildren that often. So hey, we've inherited this house or this land, and now we all own it together, and we've got to work together and figure out what to do. So transparency and having a plan that makes sense.
A couple of moments left with Marshall Chriswell this morning. With what you just said, does it happen often that after the agreements are all written up and everything is taken care of, that the parents then say to the children who will be the heirs, if you don't understand this, let's go to the attorney and talk, and he can explain it to you exactly what's going to happen and answer all of your questions. Does that happen often?
Yes, it does, and
it should.
And it should. I always encourage that. Obviously, I'm having with the folks that have hired me, I'm having confidential communications with them. But then we can, if everybody consents, yes, we often have. I have a conference room in my office, and sometimes I walk in and it's packed to the gills with the parents and the children and everybody, and we just lay it all on the table and talk about it. And I think that's a great idea.
Yeah, as long as they aren't Hatfields and McCoys, we ought to be okay.
That's right.
So if somebody is thinking about this, obviously they want to get in touch with you, and you want to work on this with them. And as you have said before, Marshall, when you get that initial consultation, if you don't have that estate plan, don't worry about bringing all kinds of stuff with you. Let's just sit down and talk, and then we'll determine our course of action from there.
Yeah, I always send out a questionnaire to new clients, and I just ask that you fill that out before you come in. It just gives me the basic information, regarding your assets and your family, and that's really all we need for our first conversation. Yep.
Yeah. Okay. Good plan. All of that being the case, what should people do if they want to get this process rolling?
Call me at 724-465-5826. Stop and see me in the R&P Cole Building, 655 Church Street in Indiana, or go online to www.westernpalawyer.com.
Marshall, thanks so much for being with us today.
Thanks a lot, Todd. Take care. Have a good week.
You too.
Take care. Have a good week.
You too.